Good morning. My name is Karen Cocq, and I'm with the Migrant Rights Network. With my colleagues here today, we are here on behalf of over 300 organizations from a broad cross-section of refugee rights, civil liberties, gender justice, and migrant advocacy to demand the withdrawal of Bill C-2, the so-called Strong Borders Act. We are unified in our opposition to this sweeping and dangerous legislation. Today, we will outline concerns about Bill C-2 detailed in 4 separate open letters and statements that emerged simultaneously and spontaneously in reaction to this egregious bill. Copies of these statements will be distributed at the end with your press packages. Such is the outrage that additional statements continue to emerge daily. The signatories of these statements, from refugee rights groups to civil liberties advocates, from gender justice groups and health advocates to labor unions, they represent hundreds of thousands of people, migrants and citizens alike, with one clear message: Bill C-2 must be withdrawn. Bill C-2 is not a border bill. It is a power grab and an attack on fundamental human rights and civil liberties for every living person in this country. Bill C-2 is an intensification of the all-out war that has been waged on migrants for the last 2 years. A rapid-fire series of devastating cuts to immigration programs and levels has changed immigration rules in the middle of the game for millions of people, leaving them in limbo. This year alone, 1.2 million people will see their study and work permits expire without any options to renew them. Bill C-2 exploits this man-made crisis, putting hundreds of thousands of people's livelihoods and lives at risk. C-2 is an unprecedented expansion of surveillance powers. It is a violation of the Charter and international refugee obligations. The bill would give the government the power to change, suspend, or cancel any immigration permit or application, including for those who have already received their permanent residency cards. This bill would give the government the power to take away rights from migrants and people who are on their way to citizenship, and the power to do this for entire groups of people at once, with no possibility of individual appeal. Migrants could lose status en masse overnight with no legal recourse. This will force more people into conditions of abuse, exploitation, and even death. For the last 2 years, migrants and refugees have been scapegoated for the housing crisis, for inflation, for unemployment. This is, of course, good politics and good business, distracting the public from those truly responsible: politicians and their policies that benefit corporate interests profiting from the financialization of housing, the fixing of food prices, and the suppression of wages. Prime Minister Carney promised to be different from the previous Liberal government and different from Trump. C-2 shows us that he is, in fact, neither. Instead, aligning Canadian immigration and policing with the U.S. and going beyond, giving himself tools even Trump does not have to finish the attack on migrants that his predecessor started. Already we have heard the Conservative leader promising to ensure that Bill C-2 does not impact, quote, long-standing Canadians, end quote. A thinly veiled racist euphemism that aims to divide and conquer and reveals the truly xenophobic foundations of this bill. We reject this division, and we are here today to say to this government that we will not stop until Bill C-2 is withdrawn. I will now introduce our next speakers in this order: Gauri Sreenivasan, Co-Executive Director of the Canadian Council for Refugees, who will be followed by Tim McSorley, National Coordinator for the International Civil Liberties Monitoring Group, and Debbie Owusu-Akyeeah, Co-Director of Policy and Advocacy at Action Canada for Sexual Rights.
Good morning. Thank you, Karen. My name is Gauri Sreenivasan, Co-Executive Director at the Canadian Council for Refugees. Bill C-2 is proposing profound changes that seriously weaken Canada's system for offering protection to refugees who are seeking safety at and within our borders. These changes are deeply out of line with fundamental human rights, rights that are protected both under the Canadian Charter and international law. What kind of a country do we want to be? Je répète en français. Le projet de loi C2 change profondément le système de protection pour les réfugiés qui nous demandent l'asile au Canada. Ces changements sont tout à fait contraires aux droits fondamentaux protégés par la Charte et le droit international. Qui sommes-nous? Quel genre de pays est-ce qu'on veut être? 3 key points. This bill would have us be the country that would deport someone back to the dangers they are fleeing without a hearing to weigh the merits of their case, merely because they came to Canada more than 1 year ago. Whether or not the context in their country has changed, or their personal or professional life has changed, making them a new target. This lifetime ban on access to protection in Canada copycats an American policy, but incredibly actually makes it worse. Who are we? Second, this bill would make it even more difficult for people who cross into Canada from the U.S. between ports of entry to have their asylum claim heard by the Immigration and Refugee Board, the institution that is the envy of the world and that is expressly designed to hear such claims, a system born from a Supreme Court ruling whose 40th anniversary we just celebrated. This bill lacks Canadian logic and pride. By driving claims away from the IRB and towards the inadequate tool of a pre-removal risk assessment, the bill will merely shift the refugee backlog from one place to another, passing the burden to an already strained immigration department and the federal court. And third, the bill gives this government unprecedented discretion to cancel, suspend, or change any individual or groups of immigration applications or documents, from travel authorizations to work and study permits, as long as it's deemed in the public interest. The vagueness and the lack of safeguard in this creates reasonable fears that the government is giving itself powers to treat an individual or whole groups of applicants unfairly because of where they are from or how they arrived. This not only creates major risks of discrimination and injustice, particularly for racialized communities, it creates fear of injustice and fear of profiling and racism, which is corrosive to the public confidence in the immigration system. This is not the direction we want to go as a country. Bill C2 is presented as being about public safety. Let us be clear. None of us will be safer if we remove protections from those who need them most. If the government wants to address concerns regarding illegal drugs and guns, let them introduce targeted legislation to do so. Elbows up to prevent a takeover of Trump-style protections of families who need protection, of Trump-style deportation of families who need protection, and arms out for each other. This bill must be withdrawn.
Thank you, Gauri. I'm proud to be here joining my colleagues from so many different sectors, all with one clear message, that Bill C2 must be withdrawn. I'm here in my capacity as a national coordinator of the International Civil Liberties Monitoring Group. We're one of the 39 organizations and 120 individual signatories to a joint letter released today that raises the alarm on how Bill C2 is a multi-pronged assault on the basic human rights and freedoms that people across Canada hold dear. Nous faisons partie de 39 organisations et des plus de 120 signataires individuels de notre commune qui lancent un cri d'alarme sur la façon dont le projet de loi C2 constitue une attaque sur plusieurs fronts contre les droits de la personne et les libertés fondamentales qui sont chères aux personnes à travers tout le Canada. Notre message est clair, ce projet de loi devrait être retiré. Bill C2 is framed as a border bill, and while some aspects do relate to the border, many of them themselves which are deeply worrying and problematic and dangerous, this bill goes much further by including an enormous and unjustified expansion of power for police and CSIS to access the data, mail, and communication patterns of people across Canada. There are many areas of concern in this bill. In our letter, we focused on 3 specific issues. First, Bill C2 would allow for a massive expansion of domestic surveillance. Without a warrant, police and spy agencies could demand information about our online activities with any business or digital service. With a judge's approval, law enforcement could compel any company to provide a much wider range of our personal information than current laws allowed, all based on whether they think it might assist with an investigation. This shockingly broad system undermines privacy rights and is ripe for abuse and must be rejected. Second, This expanded surveillance infrastructure would grant reciprocal powers to foreign governments. New frameworks would allow the United States government and other foreign countries to demand sensitive data from Canadian service providers, possibly to criminally investigate activities that are legal or even constitutionally protected in Canada. Finally, we share the deep concerns, as expressed by colleagues here today, that Bill C-2 abandons multiple refugee and asylum obligations that Canada has a responsibility to uphold under international law. It's outrageous that the first bill that this government has introduced is omnibus legislation that would seriously undermine the charter rights of people across Canada by empowering domestic and foreign law enforcement and spy agencies to have easy access to our personal data. This cannot be allowed to pass. It is dangerous and will put people will harm people across the country. Our message is clear. Bill C-2 must be dropped. Thank you.
Thank you, Tim. At Action Canada, we are deeply committed to championing and safeguarding the human rights of everyone, in particular those who are looking for access to adequate and accessible reproductive health care. And it's one of the reasons why we endorsed the statement that was drafted by the Barbara Schleifer Clinic. Along dozens of other organizations, we are ringing the alarm and calling attention to the threats that Bill C-2 poses to the fundamental human rights of refugee claimants. In particular, undermining their due process and restricting access to justice, which would have profound impacts to survivors of violence, particularly those who are racialized, Indigenous, 2S LGBTQ, and those with precarious immigration status. Canada has a duty and a responsibility to be a global leader at this moment, as we're experiencing a massive transnational backlash against newcomers and refugees. This bill does the opposite of that leadership, and I think it's important to specifically name the commitments to international law that Canada has. Canada has committed to the Convention on the Elimination of All Forms of Discrimination Against Women. It's also a signatory to the United Nations Refugee Convention and the Global Compact on Migration. Bill C-2 will introduce sweeping changes to our refugee and immigration system that fail to acknowledge the realities of survivors of gender-based violence. Imposing stricter time limits, for example, on marginalized refugees ignores Canada's commitments to gender equity and to safety. Now just imagine, you are a young person or a woman who is escaping a life-threatening situation in your home country. You're dealing with profound trauma, but you have a deep desire to be safe, finally. And you believe you have that when you finally arrive here. Now imagine that feeling of safety being ripped away from you and your rights, as you're now forced to deal with rigid timelines for your claim process, government bodies being granted to make decisions about you on a whim, information being shared about you without your consent, including if you accessed an abortion, and your migration to Canada, like many others, continuously being seen under the lens of criminality. Where is the dignity in that? Where is the trauma-informed process, and where is the care? We do not need to choose between protecting survivors and ensuring that there's public safety in this country. We are demanding better, and we urge Canada to engage directly with frontline organizations and survivors to understand the real-world impact of this legislation, to ensure that no survivor is denied protection due to procedural barriers or irregular entry, and to uphold Canada's international and domestic commitments to gender equality and human rights. Thank you.
Thank you very much to all of our speakers. You have heard today from organizations that represent refugees, civil liberties, gender justice, and migrant rights. What unites us is our refusal to accept Trump-style politics, no matter the party logo. We have said for years that immigration status is the linchpin to equality, and which is why we have been calling for permanent resident status for all for years. And this bill is the opposite, a continued obsession with the numbers of migrants and immigrants and refugees in this country instead of with the rights that they have. This draconian attack on human rights and civil liberties cannot be tweaked. It must be withdrawn. The government with Bill C-2 has come for all of us, and we are all standing firm, united here representing hundreds of organizations and hundreds of thousands of people in this country, to demand a complete withdrawal of Bill C-2 and to say to this government that we will not stop until that happens. We will now take questions. Yes, Mary?
Yeah, hi, Mari Wolf from the Globe and Mail. I wanted to ask Tim, you mentioned that this may open the door to data sharing agreements with the United States. Can you point to which bit of the bill, addresses this? And equally, do you have any concerns about the Cloud Act?
Yes, thanks so much for that question. So the specific section of the bill is Part 14. Under that part, it would allow both for the greater access of Canadian law enforcement and national security agencies to private information held in Canada about anybody in Canada, not just Canadians. But it would also grant reciprocal powers to foreign entities, including the United States, in order to make requests for Canadians, and not just Canadian, for any data held by Canadian service providers within our country. In calls in a technical briefing with the government, they confirmed that part of the reason for this is to meet Canada's potential obligations under new treaties that are being negotiated, including the second protocol to the Budapest Convention on Cybercrime, which involves deeply worrying powers to be able to share information and provide information to foreign law enforcement agencies, as well as to bring it in line with current negotiations that the Canadian government is undertaking with the United States in order to form an agreement under the U.S. Cloud Act, which has been roundly criticized for allowing U.S. law enforcement easier access to the data held within Canada and relating to people within Canada. And I think it's really important to point out right now that given what is happening in the United States and in many other countries where we see the rise of authoritarianism, attacks on fundamental rights, that the ability for these countries, including the U.S., to more easily access personal information is very dangerous. As Debbie pointed out, under this, they would be able to request whether or not an American who has come to Canada to seek an abortion was provided that service, and then criminalize them in the United States for something that is constitutionally protected here in Canada. It would also allow for them to seek information about people's immigration status, whether or not they've been involved in protests and things like that, and then use that to criminalize people, arrest them, deport them as we've already seen in the United States. So at a time when we need to be thinking about how we protect the data that's held in Canada, the government's going in a complete different direction.
Yes, hi, I'm Jesse with the Hill Times. I was just wondering if anyone had any response to organizations that support this bill, like the Canadian Centre for Child Protection, that argue that if the changes that it would implement would help reduce the barriers police face when investigating online crimes targeting children.
So there are sections of the bill around that do address more directly. So I'm trying to remember the section, but I believe it's section 5 that directly addresses that. We're concerned that the provisions under section 14 for information sharing would be much broader. If the government wants to look at targeted laws and wants to have a debate specifically around how do we protect children from abuse, then we need to have that conversation, but it can't be buried within an omnibus bill that's being presented under the guise of protecting the border. So, we don't disagree that these organizations, have valid concerns about limitations that currently exist, but we don't, we have concerns that the provisions of this bill go too far, but also just fundamentally, we can't have that discussion when they're just buried inside this bill. Once it goes to committee, they're going to have to discuss every single aspect of this bill. There's going to be very little time, very little opportunity to really get into the specifics. If the government wants to discuss this, they need to withdraw Bill C-2 and come back with specific legislation that we can then actually debate.
Good morning, Raf from Canyon CBC. When I spoke to the immigration minister last week about this, she insisted that everything that's being granted to her office in terms of extra powers would only be used in cases of emergency. She cited, for example, the COVID pandemic and something like that, repeating itself as a reason to be able to cancel mass immigration documents like in a big group, let's say. And she also said that they just need to be able to make processing faster when it comes to refugee claims, and that's kind of why the 1 year limit is being imposed on this stuff. Can I get your response from anyone really?
Yeah, thanks very much for the question. Those are actually two different aspects, so can respond to each. The first is the consistent assurances, which we have heard as well, that this definition of in the public interest will ensure not overreach on how immigration documents are canceled or seized is inadequate. It doesn't mean that there aren't any reasons why. There may need to be a reason to look at a particular immigration document. The concern is the rather sweeping power in the public interest as defined by the Minister of the Day. It grants powers to this government, it grants powers to future governments. And so the key question is, what are the adequate safeguards? It's not just for an individual, it's for whole classes of people. And we have a history and experience in this country where we treat groups of migrants arriving in a certain way or from a certain country in discriminatory, racist ways. And so when you empower legislation and a minister to be able to do that again, it really corrodes people's trust and confidence in living in safety in this country. And it's a little bit just going back to an issue. There are key concerns about public safety that can be addressed in a bill. But this bill also makes many people less safe and feel less safe. And we cannot trade safeties across people. That's why we need targeted legislation. On the question of the 1 year ban, it's hard to argue how creating a limit that you can only claim refugee protection within 1 year after June 20th helps you process faster. The intent of this is to reduce the volume of how many people can access, to target specific populations that can no longer ask for refugee asylum, and to basically start to hollow out the role of the Immigration and Refugee Board. It is profoundly concerning because we know that the way life works, the conditions that give you risk to be at risk of danger or human rights persecution in your home country are never on a time limit. There is nothing in the UN Refugee Convention that puts a time limit on when you can ask for protection. It is actually, this 1 year bar policy is a policy that the Americans have had for a long time, which the CCR has criticized for years. But ironically, even in the US, it is 1 year from your most recent arrival, and there are exceptions and flexibilities. This is an entirely black and white. If you have ever been to this country longer than a year ago, since June 2020, it is no longer credible that you are not safe to return home. It defies logic. If you were a baby who visited Canada because you have family connections and later are someone who is a well-respected journalist in a country and is suffering persecution, interestingly, when you think about the Safe Third Country Agreement, one of its exceptions, the agreement itself, we also find completely ineffective, but it actually creates an exception that we should allow people with connections to Canada to make a claim here. So you would have had every reason to have come to Canada because you have family connections here. 20 years later, you're a well-known journalist. You come back to Canada because your uncle is still here, your brother is still here. Oh no, you should have known that when you were 8. It defies logic. So it's not about speeding up processing for the 1 year ban. It's about reducing the volume. And so what this bill is doing is, in the context of accurately perceived increased pressures on the Immigration and Refugee Board, rather than investing in its capacity to process with due care, with due process, these cases on their merits, it just doesn't end around them and prevents people from reaching the Immigration and Refugee Board, and that's our concern.
If I can just add also to that, Rafi, things like, unprecedented events like the COVID pandemic, for example. One of the things that we learned from the COVID pandemic was that COVID and other public health emergencies like that don't discriminate on the basis of race or country of origin. Laws and policies do, and this law would. And that is the concern that we have. That it is not necessary to give the government the power to be able to revoke en masse the immigration status of entire groups of people based on things like their country of origin in order to protect in a situation of a public health emergency. It is very reminiscent of the days, some of you might remember, and this speaks also to the backlog question and the volume. It's reminiscent of the days when, under the Harper government, the Minister of Immigration, Jason Kenney, effectively threw stacks of PR applications for permanent residency in the garbage to deal with the backlog and the volume. That is not an appropriate way to deal with matters that are of life and death for people. In this Act C2, that permission to change, cancel, or and to change or cancel or pause the status of groups of people would apply even to people who already have permanent resident status, who have the exact same rights in this country as Canadian citizens, except for the right to vote. What is the logic for canceling the immigration status of an entire group of people who already have permanent residency, other than to summarily and efficiently, by the government's terms, evict people from this country who have lives, who have built families, who have relationships, who are fundamental parts of our communities and are essential for ensuring that all of us can access the safety and the security and the well-being and the services that we deserve.
Could I just follow up? You seem to be saying that you want this bill to be, it isn't going to be properly scrutinised. It's a huge bill. There won't be time. But you're calling for the withdrawal of it. I'm wondering why you're not calling for it to be split in several bits, which can be, then amended and looked at very closely.
I can speak to that quickly and just say, like I highlighted in my remarks, the leader of the Conservative Party has already said that his opposition to C2 will only be insofar as ensuring that it does not negatively impact, quote unquote, long-standing Canadians. The express purpose of an omnibus bill like this is to bury the controversial parts, to bury the problematic parts, to limit scrutiny, to limit debate, and to ensure that when it gets rushed through Parliament, as it might, as we are currently seeing with Bill C5, that it forces people, other politicians and other parties, it forces perhaps groups in civil society and members of the public to then choose who they are willing to sacrifice and on what terms in order to eliminate those sections of the bill that they find most egregious. I think it is very telling that in the week since this bill has been introduced, there are, across our desks, have passed 6 separate statements and open letters that are a resounding denunciation of Bill C2 that have all called for its complete withdrawal. And this represents organizations not just that are standing here, but also health groups, labor unions, community groups, legal clinics, groups like the Canadian Association of Refugee Lawyers. So this is across the board receiving resounding denunciation from civil society in this country. And I think that that is very telling about what we understand the nature of and the purpose of this bill to be, packaged as it is as an omnibus bill, which is why we are demanding that it be withdrawn completely.
Do you think you have any allies in Parliament at this point beyond the NDP on this? I know they've raised similar concerns both on the immigration and civil liberties front, but it seems like, as you said, that the Conservatives don't seem to really be opposed to the substance of the bill. The Liberals, obviously, it's their bill, and the NDP are 7 members. Do you hope to get any parliamentarians on side?
Well, there is actually currently some questioning from each party, but each party has been focused on a different part. So there are questions coming from the Conservative Party with concerns in relation to privacy and the lawful access provisions. We have seen concerns raised by the NDP. We have seen some concerns raised by the Bloc with respect to some of the actually kind of smaller, more technical sections of the bill in relation to new aspects of new steps being introduced in the refugee claim process. But our hope really here is that it is actually overwhelming, especially in the context of PACE, for MP offices to be able to understand the potential threats. So we are actually trying to build the case for understanding across parliamentary parties about why the bill is problematic in its various dimensions, and because it is so big, dangerous, because it ultimately also comes back. You can split up the bill and goes to different committees, but then people have to vote on it holus bolus. So at this point, our concern is about educating and engaging, and we're really looking forward to conversations with parliamentarians so that they can understand their crucial role in a minority parliament in helping to think twice, and also with senators about where this legislation could go. So it's early days, but you're right. I think part of the problem is there's actually still not as much understanding across all the caucuses about what the bill contains. It's a monstrosity.
Thank you. That's all the time we had. Merci, c'est tout le temps que nous avions. This concludes the press conference. C'est ce qui conclut cette conférence de presse.
Merci. Thank you.